Ladies and gentlemen, good morning. Welcome to the 3rd District Court of Appeal. We have technically 2 matters on the morning calendar, but they have been consolidated. The first is C087137, Lock Management Association against Martha Esch. Ms. Esch, do I pronounce your name properly?
Yes, sir.
Very good,
Esch.
thank you.
Correct, thank you.
You're welcome. And this is consolidated with C088192, also Lock Management Association against Martha Esch. Ms. Esch, as the appellant, you have 15 minutes to present your argument. If you don't take the entire 15 minutes, you can reserve what you have left to reply to Mr. Enos after he argues. Do you understand?
Yes, sir. Thank you very much, Your Honor. Thank you.
You're welcome. All right.
And I would like to reserve approximately 7 minutes of my time. So if I go beyond that, please somebody raise your hand or wave at me. Thank you.
I'll try to remind you. Thank you.
Thank you very much. May it please the court, my name is Martha Esch. I am the defendant appellant in this matter. I respectfully request this court, in the interest of justice, fairness, and the rights of all public citizens, to reverse these attorney fees awards in my 2 consolidated appeals. The awards of attorney fees total over $237,000 stemming from a discriminatory right of first refusal policy over my purchase of a $21,000 property in Locke, California, 10 years ago. I've prepared a brief summary of my focus points and wish to reserve 7 minutes of my time to answer the questions. My oral argument focuses on just 4 of several main issues of errors made in the trial court. Number 1, no alternate dispute resolution was ever offered to me. Exactly 10 years ago on March 21st, 2011, this whole fiasco started when I became the proud title owner of a historic property in Locke, California that was described as a teardown by the realtors, but I could afford it at $21,000, and I saw the beauty of its rustic post-Gold Rush architecture. 2 months later, in late May 2011, I received a summons notice that Lock Management Association had filed a lawsuit on me, the buyer, and Donald LeBlanc, the seller, for allegedly violating LMA's right of first refusal policy in their CC&Rs and bylaws contracts. But no EDR was offered by LMA or its attorneys to either Donald LeBlanc or myself prior to suing us, and the required certificate of ADR offer was never filed with the court. Lock Management and Associates and its attorneys don't dispute this. Discussion and 3 post-judgment court hearings on attorney's fees was had in the trial court regarding the controversy of the fundamental ADR arbitration requirement for LMA, which is both a public entity and a common interest development. Yet the trial court erred in allowing the fundamental law requiring ADR and its certificate to be waived in the underlying attorney's fees awards. In Mansuri versus DeMac Estates versus Mansuri 2015. Okay, thank you. 089178. Let's see, 3. I'm sorry. The trial court erred in awarding 1717 fees as being sound in contract. Oh, this is number 4. Discrimination. I ask this court, can attorney's fees be awarded as sound in contract when the contract itself for right of first refusal violates state and federal discrimination laws? I'm sorry, can I go back a little bit to
Sure.
the award of, in the Donna LeBlanc case and her dismissal and settlement agreement with Locke Foundation like 9 months ago?
specific attention to subsection B2 in 1717 as to what just happened 9 months ago in the voluntarily dismissed appeal over that same trial court attorney fees award. 1717B2 states, where an action has been voluntarily dismissed or dismissed pursuant to a settlement of the case, there shall be no prevailing party for the purposes of this section. With that code section, I believe that Donna LeBlanc's voluntary dismissal and attorney's fees settlement with LMA over that same attorney's fees award of $202,588.59, LMA and its attorneys folded their own tent, and LMA is no longer the prevailing party. Thank you. I'll have 4 minutes for... Thank you.
We'll reserve the remainder of your time, Ms. Esch. We'll hear now from the respondent. Mr. Enos, would you state your appearance, please?
Association. The appellant's challenge to the April 4th, 2018 post-judgment attorney fee award is barred because her motion to tax costs was untimely. It also fails on the merits because the appellant did not present any evidence to support her claim that the post-judgment fees were excessive or duplicative. Contrary to this, the Lock Management Association presented substantial evidence that supports the trial court's order. Appellant's challenge to the October 9th, 2018 post-appeal attorney fee award is forfeited because her briefs failed to cite any evidence in the record or any legal authority of her claim of error. Appellant's challenge also fails on the merits because the Lock Management Association presented substantial evidence justifying the award. The trial court properly applied the lodestar calculation and, despite claims, there was no violation of due process because she in fact received all relevant documents prior to the hearing. The trial court properly found that the proposed order was not part of the motion pursuant to California Rule of Court 3.112. Appellant appeared at the hearing and had an opportunity to present evidence and to argue this issue on the merits. Thus, there was no prejudice. And last, for the reasons set forth in our brief, the other issue that the appellant is raising is not properly before the court because they improperly challenge judgments that are final. Regardless, those improper claims lack merit. So with that, I submit the matter unless the court has any questions.
All right, Mr. Enos, thank you. It does not appear that we do at this time. Thank you very much. Ms. Esch, you have a little over 4 minutes.
Thank you. I believe that in my brief and in my reply brief and in my argument, I did touch upon what was duplicative, one way in which the fees were duplicative, and
Ms. Esch, I'm going to have to interrupt you, please. Could we get our band to start the clock, please?
Oh.
There we go. Okay. You can continue.
And October 9th, 2018, he says, I forfeited, don't know, these are to me, due process, to be able to see and know what is in the papers that are filed with the court, whatever they be. If they're the proposed order, I should still be entitled to know and to see. And the fact that 15 minutes of that afternoon court hearing that was, I believe, only like 40 minutes long, 45 minutes, which is a good-sized hearing, but still, I should not have had to take up that valuable time with not knowing what was filed with the court. So I disagree that, and then as far as being barred, these attorney's fees go to fundamental civil rights for due process and for the rights of the discriminatory issues within the contract of CC&R's bylaws and CC&R's that the attorney's fees were awarded on. It's just not right that if people can't buy property and have a common interest development public entity take away their property rights and then charge them attorney's fees. Thank you. And I wish to reserve my time for any questions you might have, Justices. Thank you.
Very good. Ms. Esch, it does not appear that we have questions at this time. And so the matter will be submitted and the court will stand in recess until 2 o'clock this afternoon. Thank you all.
Thank you, Your Honors. Thank you.